Hey everyone, it's Lauren and Jarrett hopping back on to go over what happened yesterday in court with the 5 suspects who are accused of kidnapping and murdering Veronica Butler and Jillian Kelley. It seemed to be a big day in court yesterday with some really crazy things coming up. Jarrett, can you break it down for us in terms that we can all understand?
Well, what was anticipated and what has been actually filed are two different things. There was some reporting that the larger issue of whether or not the God's misfits are all going to be tried together was an issue that was going to be addressed yesterday. It turns out, Lauren, that really largely procedural questions were asked and kind of answered yesterday. We did a video earlier yesterday talking about, you were asking about the return of property, that the defense objected to returning the victim's jewelry. So today there is an order, just by way of a little update with regard to that particular motion. In 2018, Oklahoma passed a law that basically says victims are entitled to the return of their property that is not relevant to the prosecution of the case. Why does that law exist? Because oftentimes a victim's cell phone, articles of jewelry, articles of personal value or significance are secured. And when a victim asks for those items to be returned, police officers and DAs across the country, and certainly in Oklahoma, have often said, hey, the case is ongoing, you can't have it back. Oklahoma now says if it's not relevant evidence, it can be returned. So the DA prosecuting the God's misfits says, we intend to return these items of jewelry. The defense says, not so fast, we haven't looked at it. So the court, properly, I might add, I expected this decision, says, hey, under Marcy's law, which is that victims' rights law to get this stuff back, relevant evidence is what's basically under the law means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than not. Okay, that's how lawyers talk. Bottom line is, we don't know whether or not that evidence is relevant in the eyes of the defense because they don't have everything yet and they haven't had the opportunity to inspect that evidence. So it would be premature to rule on the request to return that property. So the long and the short of it is the judge said, let's wait. That request is premature. I'm not ruling on that request. So that's what happened in that regard. There's also been a fight on the power of the underjudge, the lower court judge, the magistrate. You may remember, Lauren, you and I talked about that magistrate setting certain discovery rules before the preliminary hearing. The district judge today dropped another opinion setting forth to the magistrate saying, hey, Mr. Magistrate, here's your limited function here. Your job is to conduct a preliminary hearing for a determination if a crime has been committed and if there is if there's probable cause to hold these defendants, period. That's it. Don't be messing with my discovery. Don't be issuing orders for these defense lawyers to comply with, which is the proper law, by the way. So basically the district judge is saying, I am the final authority on these types of matters.
Not the magistrate. Got it.
Yes. So the larger question still looming, okay? And a good question you asked, and I think people have been asking, is that still leaves one major issue open. Are these cases going to be tried together? We don't know yet. And why don't we know yet? We don't know yet because it is premature for the court and the defendants to make that call yet. Even if the defendants are saying there's no way in hell I want to be on trial with, if Tad's saying I don't want to be on trial with Tiffany,
right,
or again, who knows, or Paul, it's early in the process in that all of the evidence has not been turned over to the defense. Once the defense has the opportunity to inspect all of the evidence, puts their defense together, you will have a clarification of positions. And if Tad's defense is to blame Tiffany or vice versa, or Paul is blaming the Twombly's, that is when that issue is really going to rear its head. Right now, we don't even know if they have antagonistic defenses. So the court is saying, look, I don't know enough to make that call yet. We're going to revisit that issue.
But let
So
me ask
that's
you
where-
this. Let me ask you this. So basically they're saying, because it's reported that the defense attorneys have until September 9th to submit the final arguments on whether or not all suspects should be together. And then the next tentative hearing is September 18th, where the judge will decide if the suspects will be tried together or separately. So are you saying that they're going to have everything they need discovery-wise by then to make their arguments?
Discovery in a case of this size will be ongoing up to and including the eve of trial, no doubt. So
Right.
they're
So
never
they'll
going to
have
have
enough.
everything. So the judge is basically saying, we set this date, you will likely have enough to lay out your defenses. Enough discovery has been exchanged at that point where those positions should be clarified. So, you know, if I'm the DA, I want to try these cases together and if I'm the court, I want them to be tried together because convenience, cost, having to do this 5 times as opposed to having to do it 1 or 2 times. So that's what the DA is going to be arguing. The defense is going to be saying, we would only be speculating that, you know, so-and-so, you know, Paul is blaming Tiffany. Tad is blaming, who knows?
So in your opinion, if you, and I feel this way, or I feel like if this was me, actually, you know, I don't know. Because like you said, I don't know what all they have, but I would think that I would want my own trial.
You would also, Lauren, why having the discovery take place is important because there are pieces of evidence. For example, the family law records, okay, that have nothing to do with another defendant, for example, and they may be admissible against Tiffany or against Paul for whatever reason, and not admissible against everyone in the conspiracy. And they're saying, whoa, like I'm going to look guilty or have issues with this particular piece of evidence, and it's not even being admitted against me. No instruction you give the jury is going to cure that. So these are the kinds of defenses you would have to everybody being tried together, including statements. We know Paul made a statement. Tiffany made a statement, okay? Their statements are admissible against them. If Tiffany made a statement and implicated a co-defendant, that particular statement, if she doesn't get on the stand, could be redacted. And it says, I and someone else did something. So it gets a little convoluted.
You saw that Tiffany's motion to have all of the previous records sealed was overruled. So
yeah.
that was so, and that is all the custody records.
Well, we knew that. We knew that. What really came out today was all of that information is now going to be shared amongst all of the lawyers, because we had talked about Cora's lawyers have been doing a really good job getting out in front of these things. Some of the other lawyers have been silent. What I expect probably happened is they came in court today and said, hey, judge, we want those records too, which is the proper way to ask. Cora's seem much more assertive in the paperwork they're filing. Doesn't mean the others aren't doing a fine job, but you and I are looking at this from 10,000 feet. And look, I'll be honest with you. You need to file that paperwork, though, in a death penalty case. You need to document your motions, go into court, and argue on behalf of those motions. So that family law stuff is being provided to everyone. And the judge gave them very strict instructions today. The judge says, if you file a motion that has something to do with these records and you identify the minors or you don't redact it, you're going to be held accountable. And Mr. Lead Lawyer or Mrs. Lead Lawyer for each client, you better make sure that that's happening. So the judge is very
protect the kids.
And being very careful about doing that.
And I think that, that should be everybody's goal at this point, is to protect all of those children, because they are still living this, and it's just awful. But you didn't really answer my question with like your opinion. Do they have a better chance, do you think, of getting convicted being tried together or separately? Or like, you know, like I said, if I'm a defendant, I want to go into my own trial. I don't necessarily want to be grouped with the person that admitted to everything, because what if, sure, maybe allegedly Tiffany admitted it per the affidavit, but Cora could be sitting there being like, well, I didn't admit anything.
So the answer is yes. My opinion, if they're tried together, there will be a better chance of the DA getting a conviction in the case, because it's a conspiracy. There are a lot of moving parts. It's clearer for the jury to understand if all of them are sitting together in that courtroom. Or what is likely to happen, somebody comes to the table and makes a deal. One of them gets on the stand and is pointing the finger at the others. So so typically, yes, it's easier if you have a joint trial. I've done those. They're complicated. They get a little convoluted. But again, imagine telling this story 5 times, really from 5 different perspectives.
Let me ask you this. A case like this going to trial, you've got, I always bring up Karen Reed, but that took months. What would how long would that take for, let's say, one defendant, let's say Tiffany, what do you think that would take for the state to present their case and then the defense to present their case?
Well, first of all, it's a death penalty case. So the voir dire process, jury selection will take 10 times longer than it would typically take. That's for each one. Okay. Then you have the cases, the DA's presentation. Okay. Their case in chief. Each witness could be cross-examined 5 different times if they're all together. Okay. Which could get a little redundant. And then they each could put on their case. So this is a trial that could take months and months and months. Even against one of them, the obligation of the DA is to still put on that whole case. I mean, you don't get a pass because it's one defendant. It doesn't get easier. You still have to cover Tiffany and her relationship to the victims. You still have to cover motive. You still have to cover all the forensic evidence. You still have to cover the cell phone evidence. You still have to cover the physical evidence. You have to talk about why the moms were even remotely in that area. On every case, and then what the particular defendant's roles were. It's a massive lift if these cases aren't tried together. If I'm the DA, I go to these folks, I try to get a deal with someone. I'd be listening to their prison calls. I'd find some kind of fracture in this conspiracy, and I would try to take advantage of that.
I mean, I'm just thinking about this. If they're tried separately, I feel like with that money, Texas County, Oklahoma could have built a school or a hospital. I mean, that's insane. That's going to be so much money for the county.
Yeah, it's good. Well, it's going to be very costly to do 5 trials. And that is an argument in support of trying them together. The economics of it is definitely a fact. But again, all of that is counterbalanced by the rights of the accused whose lives hang in the balance. And I'm going to tell you, governments waste a hell of a lot more money than trying criminal cases because, they're costly. Don't get me wrong. And it's a tremendous amount of resources that get expended. But I could tell you this, the rights on both sides are worth every penny. So in my opinion, that was never a strong argument as to why these cases should be tried together.
The money, you mean?
Yeah, to me, it's a legitimate argument. I always felt like the logistical argument was the stronger one. The understanding of the jury was the stronger one. So, I would really pound those components home. And really, the law supports trying them together. You have to rebut that presumption with some showing that their positions are so juxtaposed or it is so unfair to allow them to get tried together that it is a perversion of justice.
Right.
And
the last thing you would want here is a mistrial and to have any of these suspects tried again after all that. So totally agree with you. Whatever, the court rules here is hopefully most likely in the favor of getting a conviction and having it stick. But I get it. Now it's a death penalty case, so there's a lot more to it. it's going to be, a lot longer of a jury selection. And then you've got the penalty phase at the end of every trial, right? Which is
5 mitigation experts. Each defendant would employ a mitigation expert to fight on their behalf in the event they're convicted, to advocate to save their life. Those folks are extremely expensive. It's a rare skill set, professional specialty. With 5 people, you're probably going to be bringing somebody in from out of state or well out of the area. I can't imagine the county has 2 or 3 fine mitigation experts that could testify with 5 defendants. It'd be a conflict to have one doing all 5, I think. So it is a heavy lift. And that's why all of the reasons that pushes this case out. We have not even had a preliminary hearing yet. 2026 is ambitious.
Well, okay. And so preliminary hearing, if it's ruled that all 5 defendants will be tried separately, it was reported that Cole Twombly would have the first hearing. It's already scheduled for, I believe, let me see, December 17th at 9 a.m. And that looks to be just random. Like, he has the first hearing. It's nothing to be looked into or anything like that. But wow.
So it's weird, though. In Pennsylvania, we don't call these matters preliminary hearings. These are the pretrial motions they file.
Right now.
So when I say preliminary hearing, I'm talking about that initial magistrate hearing. Okay. So if you said Cora Twombly's, or who's the schedule?
Cole would have the first pretrial hearing.
Right. I wouldn't read, but I'm going to check, because I don't know if there's been a determination as to whether or not they're going to have individual preliminary hearings.
Okay. I mean,
you're going to have the same challenges in that realm, because that preliminary hearing is not something that's going to be quick. It's going to be involved as well. So I thought what people were asking you was, because that's scheduled separate, is that a kind of a punt on the issue of whether or not they're going to have separate trials? The answer, whatever that proceeding is for Cole Twombly, is no. The judge has not decided.
Right.
The higher judge has not ruled on that particular issue.
Right. So I guess I'm just thinking, after September 17th, if, let's say, the judge rules it's separate, there's not really another hearing set until December, is what it would appear to be.
Right. Unless something comes up in the meantime, which things are coming up pretty regularly in this case. So I would imagine there'll be some filings, but nothing scheduled.
Now, let me ask you one more thing, and this is just kind of random, but, Tad Cullum is the only one that's using an attorney a defense attorney that he pays for, right? We've discussed this, the acquittal queen. They seem to be rather quiet, I guess. What do you make of that? You've said Cora and Tiffany's lawyers appear to be really aggressive, really staying on top of things. And as I stated, Tad seems to just have requested some law books and some other things, but there hasn't really been much there. And additionally, Cole has even been more, I guess, I don't know what you want to say, but he got a new lawyer. So I'm just wondering what you make of all that.
So I don't read too much into it. Every lawyer has a different style. If you're paying privately, you would say to that attorney, I want my money well spent. I don't want fruitless motions that are going to get me nowhere. I want money spent on investigators. I want money spent on you getting ready for ultimately this thing's going to trial. Obviously, if there's a legitimate suppression issue, pursue that for me. But, remember, it's not it's not Tad's money. It's not Tiffany's money when they're filing these things. So when you have your own, who has their own lawyer? Tad?
No, Tad. He has his own lawyer.
Okay, so it's Tad's money. So Tiffany and Cora and the Twombleys and Paul have state-paid lawyers.
Yeah.
They have no downside to asking their lawyer to file these particular motions. Tad is flipping the bill for his lawyers at this point. It's going to get really expensive, though. I don't know what Tad's financial situation is, but it could get very, very costly very quick. And I'm sure his attorneys have had that discussion with him and say, hey, look, we're talking $150,000, $200,000 for this defense. How do you want that money spent?
Right. Okay. That makes so much sense. I'm forgetting that you have to pay lawyers hourly sometimes. So God, this is just a side note. When I worked in digital marketing, and I don't know if this is a lot or a little, I mean, to me, it seems like a lot, but in digital marketing, when we were going through any kind of lawsuit, our firm cost $900 an hour. Is that a
Well, and
lot?
that's in New York.
Yeah,
So
that's New York, but like, what? I
yeah,
mean,
I mean, in the rates, like I practice here. I'm in my office here in Pennsylvania. Our rates don't necessarily approach that, but
right.
it gets costly. And think if you're paying $500 an hour, you spend 4 or 5 hours a day working on a case, it adds up pretty quick.
Yeah, yeah. And I guess, I mean, $900 an hour is a lot. I guess I just meant like, is that a lot for a corporate attorney's office to charge? I mean, one time, Jarrett, they invited us out to lunch and they charged us for the, isn't that so
You gotta
sick?
love
It's
it.
sick. I know. I'm
I
like,
always said if I got paid for the time I didn't bill for, I'd be a billionaire.
there
But
you go.
um,
There you
but
go.
yeah, look, it's all over the board. There's lawyers that are charging 3 times that an hour, believe it or not, in New York. And I'd imagine some of our friends in New York get a lot of money for the high profile cases they do. So
You're
it's
right.
hard to say. But really, when you're playing in that corporate world
Yeah.
in New York City, Philadelphia, LA, obviously they're going to command the big money. When you get a highly specialized cases like patent litigation and tech type cases, corporate acquisitions, those bills get really, really high very fast.
I wonder how much the acquittal queen charges. I'll have to look
So,
into
so
that.
who gave her that title?
I'm pretty sure herself. She is the self-proclaimed acquittal queen. That's her uh website. I'm almost certain. Acquittal
That's,
queen. Yeah.
I once had a lawyer identify himself to me as a tiger. He goes, "I'm known as a tiger," and I said to him, "By who? Your wife? I mean, who calls you a
Oh
tiger?
my
I want to know who calls." I want one name of the person that called you a tiger.
Here,
He
this
couldn't
is
come up with one.
no, seriously, this is her site, the Acquittal
Let's
Queen.
see.
You can acquittalqueen.com. Can you see it at the top?
Yes.
Okay. There you go. And that's also her yeah. I wonder. Interesting. Okay, it's not her email. She has a Yahoo email address.
Well,
Can't spring for the the domain, I guess. Anyway. All right. Well, thank you so much, Jarrett, for
too
breaking this
busy getting
down.
everybody acquitted.
Oh yeah, exactly. She's way too busy.
I look, I don't know. That's not a comment on her abilities. I don't know who that. I mean, I've certainly seen the paperwork here, but I can't comment on her ability in court. So.
Well, maybe we'll do another episode when other motions are filed and you can break down what you think of her, her memos and whatnot.
I'd imagine her acquittals come from her prowess in the courtroom and not necessarily on paper. So I'm anxiously awaiting that.
That was very diplomatic of you. All right. Well, thank you so much. I know everyone really appreciates your breakdowns in terms that we can understand. I myself especially do, so I can keep up with the case. All right. Well,
tell everybody to like and subscribe too, because we're getting these are coming out pretty regularly. So if you want an update, you want a notification when a new update drops, like and subscribe.
Yes, there you go. All right. Thanks, Jarrett. I will talk to you soon.